This is Chapter 6, Witnesses. Let's start off by looking at page 144 of your textbook and read the myths about witnesses at trial and the facts about witnesses at trial. Myths. Only people older than the age of 7 years can testify at a criminal trial. Any witness at a trial can testify about his or her personal opinions on what happened. Impeachment means the witness is not allowed to testify. Hypothetical questions are not allowed at a criminal trial. Expert witnesses must have a PhD and must teach at a prestigious university. Those are all myths. Those are all false. Let's talk about facts about witnesses at trial. There is no specific age limit. The person who testifies at a trial must be able to understand the duty to tell the truth and be able to communicate to the jury. Expert witnesses are allowed to give their opinions. Lay witnesses can only testify about the facts they observed with their 5 senses. Impeachment means that the attorney for the opposing side established one or more reasons the jury should not believe the witness's testimony. During deliberations, the jurors will decide whether or not to believe each witness. Expert witnesses may be asked hypothetical questions to state their expert opinion about the facts that have been introduced at the trial. Lay witnesses may not be asked hypothetical questions. Expert witnesses must have education and training in the field that they are testifying about. There's no requirement for experts to have a PhD. There's no requirement that they teach at a college or university. And those are the facts. Let's look at slide 5 of chapter 6, Competency of a Witness. There's 5 key issues that this chapter covers regarding witness competency. Who is competent to testify? How is the credibility of the witness attacked or bolstered? What can be done if the witness's memory is faulty? What can a lay person testify about? What can an expert witness testify about? The top of page 145. Competent witness is a person who 1. Understands the duty to tell the truth, and 2. Can narrate the events in question. Slide 6. Characteristics of a competent witness. The duty to tell the truth. The testimony must be given under oath or affirmation. False testimony is punishable under perjury. Problems arise with testimony by children or the mentally ill. Duty to narrate the events. Witnesses must be physically able to speak and recall events. Witness must be able to speak English or a proper translation. Procedure to establish competency. The procedure is done before testimony. This is called voir dire, which means speak the truth. Page 147 of your textbook. Procedure to establish competency. If there is a question of the witness's competency, a hearing will be held before the person takes the stand. The jury will not be in the courtroom during the session. Questions will be asked of the witness to determine if he or she is competent to testify. This is called voir dire. You've heard voir dire already. Voir dire is also the term used to question jurors for selection. Voir dire is also used for expert testimony questioning, which you'll see in a minute. All right, slide 7, impeachment. Impeachment is attacking the credibility of a witness. It's typically done during cross-examination of the witness. It can be done by calling another witness. 6 main methods of impeachment include bias or prejudice, previous felony convictions, immoral act or uncharged crime, prior inconsistent statement, inability to observe, and poor reputation. Under bias or prejudice, slide 8, show a motivation based on profit or emotion. Show relationship, racial, or financial motive. See the examples on page 149 of your textbook. Prior felony conviction. Traditionally, felons were barred from testifying. It's now used to attack credibility. The Federal Rules of Evidence 609, impeachment for past offense, generally only felonies can be raised. Past crimes should be related to honesty or making a false statement. And the Federal Rules of Evidence 609 is on page 153 for your review. Slide 10, impeachment, continued. Immoral act or an uncharged crime. These acts should relate to truthfulness. These are past crimes with no conviction, and immoral acts can be used to impeach a witness. There's examples on page 154 155 for you to review. Prior inconsistent statement. Past statements need not completely contradict current testimony, but you need to prove past statements were made. Non-Miranda statements may be admissible. Inability to observe, based on a physical handicap, location, or distraction. Look at page 156, inability to observe. Inability to observe usually has one of the following causes. 1, physical impairment of the witness. 2, obstruction at the scene. Or 3, the witness was too far away to see or hear the event in question. Reputation. Attacks are usually restricted to traits of honesty. Slide 11, rehabilitation is an attempt to restore credibility of a witness who has been impeached. It's usually done during redirect of the witness. Methods is to show good behavior, offer an explanation about prior inconsistencies, show lack of impairment, or use an expert witness to rehabilitate the witness. It's often used to testify to good character or reputation. Page 158 of your textbook. Rehabilitation is the restoration of the credibility of a witness. Once a witness has been impeached, the side that originally called the witness will try to convince the jury that the witness testified truthfully and should be believed. Attempts to rehabilitate witnesses are done during redirect examination. Sometimes the judge will allow a new witness to be called to support the credibility of an impeached witness. Where impeachment focused on prior criminal conduct, rehabilitation tries to publicize good deeds. Look on page 161 of your textbook. Table 6-1 is a great summary of impeachment and rehabilitation of witnesses. So read through that, and I will plan to make a copy of that to put with the PowerPoint lecture as an additional attachment. Slide 12, corroboration. Corroboration defined as bolstering the testimony of a witness by offering supporting evidence or testimony. It's mandatory when one party to a crime testifies about another party. Some states require it in cases of false pretense, and rarely now is it required in cases of rape. If it's not mandatory, it's still incredibly valuable to support the theory of a case. Look at page 163 at the top. Corroboration must be distinguished from cumulative evidence. Evidence is corroborative if it confirms previous testimony by the use of another source. Cumulative evidence merely repeats what is said. So, physical evidence is frequently used to corroborate testimonial evidence. Cumulative evidence would be multiple witnesses that are giving the same testimony. That's really a good example of a difference of the two. Look at slide 13.